Hi, everyone, and welcome to our webinar on COVID and real estate disputes. My name is Andrey Zelenin. I'm a partner at Lidings, a Russian law firm advising local and international companies in Russia and CIS. Today's event is a part of a series of LF Talks, which is a series of online events under the framework of International St. Petersburg Legal Forum. Within the next hour or so, we'll be discussing a number of various important topics related to commercial landlords and tenants arising due to the COVID pandemic. A couple of technical issues before we start. We'll have a Q&A session at the end of the event, but feel free to ask your questions via the online chat you see under the video player, and we'll do our best to answer them during the event. Also, we'll be holding a couple of polls by clicking the link you see under the player, and also by scanning a QR code you would see on the slides. With this, I want to pass on the word to my fellow panelists. Amanda, Alexander, David, please feel free to introduce yourself.
Good afternoon. It's really good to be here with you today. I'm a partner and head of the real estate disputes team at Howard Kennedy, a London-based law firm. We just advise in relation to the UK jurisdiction. We act for landlords, tenants, mainly retailers, restaurants and leisure clients, developers and investors.
Good afternoon, everyone. My name is Alexander Khavin. It's very nice meeting all of you. I'm a senior lawyer at Mango Fashion Company, and I'm in charge of all legal issues in Russia and Eastern Europe. So today I will try to share some experience that I have in these countries. Thank you.
Good afternoon, everybody, or good morning from my desk here in Atlanta, Georgia, in the US. I'm David Marmins. I'm a real estate litigator and partner at the law firm of Arnall, Gregory. I'm also a leader of a retail industry team. We have about 35 lawyers that does transactions and litigation, all things related to retail real estate. So for the last 8 months, I've been sitting here fighting on behalf of both landlords and tenants over leases for the majority of my time. So hopefully we can share some interesting stories and insight into what's going on around the world with these issues.
Yeah, thank you, colleagues. And let's start and have a great event. So on the next slide, you'll see a plan for our discussion. We'll start with the protection for tenants granted by the respective governments in our jurisdictions. We then continue discussing force majeure, eviction, liquidation, insurance, negotiations, and we'll end with sharing our ideas on the new landscape which would emerge after the pandemic. So let's go for the first topic, for the tenants protection. And I'd like to start with Alexander, who can share his views on how various EU jurisdictions are coping with the issues related to real estate leases.
Yeah, thank you, Andrey. So yeah, as an in-house lawyer, of course, the whole pandemic situation, it was a nightmare. So when it began, it was a nightmare for our company and for us as the lawyers of the company. And of course, it was like during several months we were checking how the situation changes in all the countries. And in the end of the day, I can say that almost all the countries which I'm in charge of, they issued some specific laws, some specific legislation regarding the COVID and let's say anti-COVID real estate and commercial measures. So as I said, in all the countries, there were some new special laws on, they issued some new special laws on protection for both tenants and the landlords. And for example, in Poland and in Germany, they called it anti-crisis shield. Of course, well, every law in every country, it has it just explains if a party is eligible for some protective measures, and how to, well, if for example it was stated in a law, in most all the laws, it was stated if it was possible to terminate a lease agreement or not possible, like what to do with the eviction and so on and so forth. We will talk about that later. And for example, in some countries, in Romania, for example, it was also agreed that it would be a bankruptcy moratorium for the period of COVID. But like as I just said, in Romania, it was a bit a long way, because they were almost the first who started with some legislative measures, but then it was changed many times. And in the end of the day, the main idea of all the laws which we examined, the main idea was that there was a direct or indirect help, financial help from a state to tenants under certain conditions. So it was like you can see on the slide in the example in Czech Republic and Slovakia and Romania. So different ways that the countries decided to protect business, but of course the main idea is that they decided to protect it, but of course the ways they chose, they were a bit different. So I think, well, during today's discussion we'll talk more about that.
Yeah, sure. Thanks, Alexander. And I might be adding here for Russia that there has been a lot of work for the legislature and for the executive authorities, because obviously no one has been prepared, and a lot of decisions have been made on the go that in their turn required nearly same-day amendments to be accurate for the situation that has been changing ever since this COVID scenario has started. In Russia, there's been a law adopted that was specifically targeting various COVID protective measures, and it provided for two solutions that tenants can use. One is the abatement, and the other one is the deferral. The deferral was limited to the impacted sectors. So there was a list adopted by the government for sectors like retail, hotels, and some other areas that had to close their activities due to the pandemic. And the way it works is that the tenant can approach the landlord with a request, and unless there is a clear response granted, this deferral can be considered as provided on default. And there's been also an additional ruling, or better say a review issued by the Supreme Court, that the deferral starts not from the moment the tenant has asked for the deferral, but it starts from the moment where it stopped being able to use the premises. As to the abatement, the situation is more tricky because the law said that the tenant can ask for the decrease of the rental payment, but there's no clear obligation for the landlord to provide such a decrease. So it's more a negotiation factor. At the same time, within a couple of weeks after this first law has been enacted, another one has been passed, which provided a special exemption for certain categories of the tenants, specifically the SMEs, that in the event the reduction of rent is not provided, then they can seek for termination. And that's obviously a very easy exit for a lot of small and medium-sized businesses. However, and I think we'll talk about that later, most often such mechanism has been used as a tool to renegotiate the lease term, not just to terminate it. How is the situation in the US, David?
Well, very different than what you've just described. There are a lot of abatements and deferrals and things going on, but they're all by agreement. There's no federal protection of tenants. There have been residential tenants protected by eviction moratoriums where you're just not allowed to proceed with evictions of residential tenants. But for commercial property tenants, there's been some local, state, and city issues that local jurisdictions have stopped evictions temporarily, but all those are over as well. And now landlords can go to court to seek to evict retail and other commercial tenants that aren't paying rent. But from a practical point of view, those things really aren't happening because the courts are so delayed in hearing these matters. I know I've got a couple of tenants that I represent, some retailers in Chicago, Illinois, and they were sued for eviction months ago, and their hearings have been pushed back until at least January. I know where I live in Atlanta, there's been for example, no jury trials in 7 months in courts that typically have them going on every day. So while our courts are doing many things virtually, the eviction suits are not moving forward. There is federal protection, not protection, there's some federal assistance. If you've heard of the CARES Act or the Payment Protection Plan, this is federal legislation that provided some forgivable loans to commercial tenants to help with their payroll and with their rent. But that's different. If there's a lot of restrictions on those and when they can be forgiven, those loans, and how you have to use that money. But regardless of that, if you don't pay your rent, you're not protected in the U.S. by anything other than your contract or other laws that we can talk about in a minute. But when it comes to evictions, there's no federal protection here.
Amanda, your turn.
So in the UK, the first legislation introduced by the government was to protect residential tenants. And a stay was put on all existing possession proceedings and a ban on any new possession proceedings until the 30th of September. So that stay and ban has now been lifted, and possession proceedings have been reactivated. Like in America, there is a huge backlog with the courts, so many of these cases won't be heard until next year. But it's going to be interesting what's going to happen in the next few weeks, because in the UK, we've had a furlough scheme, where the government has supported employees who have temporarily been unable to work, providing financial assistance. That furlough scheme comes to an end on the 1st of November. The UK is looking as though it's heading for a further full lockdown. So it does remain to be seen whether the government is going to introduce a further stay on residential possession proceedings. On the commercial front, as with David in the US, there's no legislation abating commercial rents. Any abatements are by negotiation, but what the government has done is introduce legislation to restrict the remedies available to landlords when tenants haven't paid rent. And we'll be talking further about evictions. One other means that landlords try and recover rent is by sending in enforcement agents who seize goods to the value of the rent. That's been banned now, or there's a moratorium on that until the end of the end of the year, as with forfeiture or termination of leases.
Yeah, thank you, Amanda. I think we can now go to the next slide and try how our polls work. So the next topic is force majeure and the related legal concepts. So you can either scan the QR code or type the link, though it's more difficult. You'll also see the link under the video player. You can access it and cast your vote. So while you do that, David, why don't you start explaining how force majeure, frustrations, and other concepts work in the US?
Certainly, Andrey. This is where I've been spending the majority of my time, is arguing and negotiating over these issues. First, force majeure law is really a matter of contract in the States. A lot of retail leases include force majeure clause, some don't, but if they don't, there are very few state or other laws that enforce a force majeure remedy for anyone. But many of these contracts do have force majeure clauses, and many of them, I would say most of them, apply to COVID-19 at this point. Early on, there was maybe some question, but at this stage, I think that most people would agree by almost any definition, COVID has resulted in a force majeure situation. The contract clauses, some of them even have pandemic references. Some of them refer to the Centers for Disease Control, which is based here, or the World Health Organization. When they declare a pandemic, then that is a force majeure under many contracts. Even those that don't specify pandemic as a force majeure, the contract clauses tend to have what I would call a catch-all provision, where anything that is not in control of the parties that prevents a party from performing on the contract can be considered a force majeure if there's that, what I would call a catch-all clause, which is very common. And in this case, certainly if the state government is shutting down businesses, a lot of these contract clauses have references to government restrictions, which prevent parties from performing their obligation. So there's not a big debate, I don't think, in most circles here, whether force majeure clauses are implicated. The real debate comes with the remedies, because most of these clauses in our contracts will say what constitutes a force majeure, and then they say, well, this is what you get, this is the remedy. And in many of these leases, this is where the tenants lose, because even though they could show it's a force majeure, there's what we call a rent carve out. And by that, I mean, the lease says you don't have to do anything that you're obligated to do under this lease if it's a force majeure, except pay rent, which is, of course, the most important thing for tenants. And so those carve-outs are respected by the US courts. If you've allocated responsibility for a force majeure event to the tenant, as far as they will incur the loss, the courts will look at that as a matter of a contractual negotiation. If you didn't have that provision, they might say, then you might have bargained for paying less rent, or there might have been some other part of the contract that would have changed if you didn't allocate the burden of a force majeure to the tenant by that carve out. Now, there are many of these leases that don't have carve outs, and we've had at least one case where a court in the United States has said that without a rent carve out, but a force majeure clause that was implicated, allowed a restaurant, at least for some period of time, to only pay 25% of their rent, because the court determined that they were open for takeout and carry out business, delivery business, and they were able to generate about 25% of their rent. So that's where the court came down, at least for a temporary solution. Now, where a lot of our fights are occurring are not on these force majeure clauses, and a lot of that's because they do have these rent carve-outs. But tenants can still argue that there are state laws among the various 50 states. There are state common law where the courts have made rulings that said, regardless of a force majeure provision in your contract, if it becomes impossible for you to perform on your contract, you're absolved from those responsibilities. A corollary theory is frustration of purpose of a contract. That's usually looked at in tandem with the impossibility analysis. Some courts will make a distinction, but it's a very high bar. And I'm going to use an example to show you sort of the different levels of difficulty of performing in a contract and how our courts look at them. And the best example I found is I've got a chain of movie theaters, cinemas, that I represent. And in the latest report of who's paying rent in the United States, the second lowest percentage of rent paid last month was gyms and fitness at about 60%. The lowest was movie theaters at 9% of rent paid last month in the United States. So it is by far the worst hit sector of the industry. And the reason for that, I'll say a little more about this in a minute, but because of their supply chain, they don't have movies to show. Going back to these levels of difficulty, the first would be something is not practical, it's impractical. For example, in a movie theater, it's difficult to stay 6 feet away. It's difficult to have social distancing and health and safety measures while still operating. So we would say it's impractical. The next stage would be where I was just mentioning, the supply chain argument. If the movie studios are not providing movies to the theaters to show, then we would argue that it is impossible for them to open. In many leases, they're required to show 80 or higher percentage of first run movies. And if the studios aren't putting those out, then it's impossible for them to operate. Now, that is one of the better, what we would call supply chain arguments in the States. There's some other issues, some other products that are having trouble getting out there, but for the most part, restaurants are getting their food and other stores are getting their products, but movies are not out there. The third stage, where your best argument for impossibility, is when something becomes illegal. And if you look at the first 1 to 2 months in most states in the United States, for March and even into April, it was illegal to open a gym or a movie theater. So that's a much better argument that the parties should not have to pay rent either. They shouldn't have to fulfill their obligations because it is not only impossible, but illegal to operate, regardless of what their contract says. Now, a lot of this is going to depend on where you are, on the location. When I've done similar presentations before, I would have said if you were in New York, then you have a much better argument because everything's shut down than if you were in the Midwest of the States. That's reversed now. New York and California went through their hardest COVID experiences earlier, and many are opening up now, many jurisdictions there, whereas today in the Midwest of the States, things are shutting down more because they're getting harder hit with a new wave. So location really matters. The states are very different in how that might apply as to how the government has restricted activity or not. The type of business, of course, matters a lot too. A lot of casual restaurants, what we call fast casual restaurants, where it's somewhere between fast food and fine dining, they've transformed their businesses to app-based delivery, to curbside pickup, and they're doing fine. And so they don't have good arguments that they shouldn't be paying rent. Whereas the gyms and movie theaters still are struggling, and they have very good arguments. And as I said, where you are, there's different shutdown orders that would apply. So that's sort of the landscape of how these issues are getting played out in the States. And this is something we're negotiating and talking about every day still after 8 months.
Yeah, thanks, David. And I think why don't we go continental here now, Alexander? What the approach to force majeure should be different in jurisdictions like yours, like ours. What do you have to say?
Yeah, it's quite curious because that's true. Then that when the pandemic began, it was in March. So our company, for example, as many other retailers, we had to stop paying rent or suspend. We had to suspend paying rent. Of course, it was a business decision, but as soon as you make any business decision, you have to have a legal basis for that. And we started examining the legislation of other countries. So in my case, I'm responsible for Czech Republic, Slovakia, Poland, well, some other Eastern European countries. And I was really surprised to find out that, for example, the concept of force majeure, it either does not exist in the country, or, for example, has no definition. For example, in Poland, there is no definition of force majeure clause, and in Czech Republic and Slovakia, there is no concept. There is no the concept. So you cannot tell the landlord that, according to force majeure, you cannot use the premises you have. You had to close. You had to, I don't know. You had to suspend the rent. So of course. In some other, for example, in Russia, this concept exists. I think you will explain it later, and it exists in Ukraine, for example. But it's always a question: if it's a force majeure clause, can we apply this force majeure clause or not? As David says, it's a matter what is written in the contract. And if I think that starting from March. Before March, I don't think many lawyers checked really precisely the force majeure clause, because it was something like something which could not happen normally. So at the same time, if you check my presentation, there is a clause, the legal concept, which is called in Roman, it's called rebus sextantibus. And as far as I know, in my native English-speaking colleagues will correct me if I'm wrong, it's called something like a hardship clause. So the idea is that of this rebus sextantibus, what we call it here, is that it stipulates that where there has been a fundamental change of circumstances, a party may withdraw from or terminate an agreement. So and that was the also, we were analyzing that in case, for example, because in some cases we had to apply this clause and to use it in order to negotiate. Another thing is some other concepts existing in the legislation of different countries is the main idea of which is that you have to prove that you really cannot use the premises. So in that case, you can be exempt. You can be exempt from paying the rent, which is a bit different. Also depending on the country. In different countries, it's different. So also, this concept, it's not always the same as the force majeure. So it was quite a challenge for us to distinguish how and in what country and how exactly we need to apply this or that concept, legal concept. And based on that, of course, the main idea was in most of the cases just to negotiate and to agree on something and finally sign some annex and some agreement regarding suspension of the rent. So, Amanda, will you follow with the UK?
Yes, sure. So in the UK, it's uncommon for leases to contain force majeure provisions. So neither landlord or tenant are able to argue that their obligations under the lease are suspended because of the pandemic. And based on previous case law, the courts are unlikely to imply a force majeure provision into a lease. Furthermore, there is no standard definition of a force majeure event under English law. So even if on the very rare occasion a lease may contain a force majeure clause, there's no certainty that the pandemic would trigger the application of that clause. Certainly, there are no reported cases as at today's date of a tenant asking the court to imply a force majeure clause, or indeed interpreting that a force majeure clause would include a pandemic as a trigger event. So what we're finding is that can a tenant turn to arguing frustration as a way of exiting their lease? In the UK, this frustration is only in very, very limited circumstances. Impossibility of performance is the key requirement here, and the English courts have set an extremely high bar for holding performance to be impossible. The position being as performance hasn't become permanently impossible by reason of the lockdown. It's merely been affected by a temporary obstacle which has now been removed, but perhaps soon to be installed again. There are arguments, though, in relation to frustration. Well, I see that there are arguments to support a case of frustration. So if the lease is very short and the lockdown has eaten into a considerable proportion of the lease, then frustration is an argument. Similarly, if a lease has a very restrictive user covenant, this may assist a tenant in arguing in favour of frustration. So by way of example, if the only permissible user has become unlawful by reason of a government order, what we are finding is that because landlords' remedies for non-payment of rent have been severely curtailed by legislation, the one remedy that is available to them is to commence court proceedings for payment of the rent as a debt. And we're finding that more and more tenants are now defending those proceedings on the basis of partial frustration, arguing that by reason of the government order to close non-essential shops and restaurants, it's become unlawful for the tenants to operate their business from the premises, and so no rent is payable during that period. I've certainly argued this for a number of my tenants, but I have argued it to try and get the landlord to engage in negotiations, and that has been successful. What I'm not aware of as at today's date, whether any sort of partial frustration defences have proceeded to a full trial. Certainly I haven't seen any reported cases on it. And so it remains to be seen whether a partial frustration argument would succeed. I mean, certainly there are many sort of who express views either way, but it'll be interesting to see whether this does actually reach the courtrooms.
Yep, it seems that it's me only left here. Try to be short because we're half past the timing of the webinar. In Russia, we have a provision in the civil code which can classify as a force majeure. So these kinds of circumstances like COVID can qualify as such, and we had this has been confirmed by the Supreme Court in the reviews that they have issued. At the same time, it doesn't work as a 100% excuse, of course, and we've already seen cases where tenants have been arguing that force majeure prevents them to, for instance, to pay rental payments, and the courts, well, both the tenants and the courts tend to be creative here. So the tenant was trying, in one of the cases, the tenant was trying to get relief from the payment obligations that were due 3 months prior to the pandemic. Naturally, the court said that that is not covered by the current force majeure. While in another case, the force majeure has worked properly, but force majeure is just a way to excuse yourself from the liability, but that does not impact the existence of the obligation itself, unless there is some specific provision in the contract. For instance, if force majeure lasts for over than X months, etc. So the legal concept similar to frustration or impossibility that we have in our civil code can also be used. So the so-called substantial change in the circumstances. This is something that has been many times tested in various crisis situations back in 2008 and 2014, etc. And we've seen that it is rather hard to go through the court filter to confirm that the substantial change is so huge that the contract should be terminated. There's been already a case where parties argued about the using this substantial change argument, like the tenant tried to terminate a rent agreement and receive the security deposit back, since the premises were not transferred by the landlord. And the claim was dismissed because, as the court said, the tenant should have taken into account possible risks when signing the agreement during the times of the pandemic. So the deposit was secured as a payment for repudiation of the agreement. So basically here it is again the timing which affected the tenant's right to terminate the contract and get the deposit back. I think we can move slightly faster, and I can now announce the results of our poll. It seems that we have a pro-tenant audience so far. Roughly 90% of our audience thinks that tenants shall prevail in these kinds of disputes, and only 10% think that it's the landlord who should be considered right by court. So now I think we go to our next topic, and the eviction. We have touched upon it a bit.
Andrey, I'm very sorry to interrupt you. Just can we probably could jump in, and because there is a question.
Oh, sure.
Because there was a question just to close this issue and to go on. So the question is from Michael or Mikhail. I don't know. I'm sorry. So it's the question about how to apply force majeure in France regarding the construction agreements, as far as I understand the question. Well, I just wanted to say, because most probably it is addressed to me, that first of all, France is not the country I'm in charge of, and the other thing, the second thing is that we're not analyzing the construction agreements, because we are more interested in real estate agreements. And, well, this is our business. And the last, the only thing which I could be probably helpful is that the concept of force majeure exists in France. So this is the only comments I could make, and I'm not sure.
Well, I think there is no easy response to that question, because
exactly. I'm pretty sure that it's not.
Okay, so eviction, and we have Amanda starting here.
So in the UK, eviction is called forfeiture, and it's a contractual right under the lease. Rent in the UK, rent is payable quarterly, and the quarter's rent fell a matter of days after the country was put into lockdown. So the government issued emergency legislation imposing a moratorium on forfeiture, on eviction until June. They subsequently extended that moratorium until September, and now it's been extended until December, 31st of December. What is interesting is that there was some shock within the industry that they had extended it further until December, because it was seen as perhaps pushing a problem into the long grass. Some tenants are acting responsibly. Most tenants are acting responsibly during this pandemic, but a lot of tenants are seeing it as, oh well, we don't need to pay our rent. We're not engaging with the landlords. And extending the moratorium has just encouraged them to continue to bury their head in the sand. What is interesting is that because although there's the moratorium, the right to forfeit hasn't been waived. So as soon as the moratorium is lifted on the 31st of December, that rent which fell due during the moratorium will immediately be payable. So we could be having a very, very busy new year dealing with forfeiture actions.
Yep, thank you, Amanda. Well, for Russia, probably I would put it right away that there are no specific restrictions from eviction itself. Of course, we can refer to the arguments discussed on the previous slides, and force majeure can definitely be used as a protection in the event eviction is used as one of the liability instruments under the agreement. However, there is a clarification from the Supreme Court that the absence of money itself cannot be considered as force majeure. So you should be very careful when building the causal link between why cannot you pay the rent and how is that connected with the COVID situation. I know if Alexander has to add here something regarding the moratorium situation in the EU.
Yeah, well, I think that well, in most of the countries I'm in charge of, according to this new anti-COVID legislation, it was a moratorium on termination was made. So in Czech Republic, it was initially, at least, it was a moratorium until I think 30th of June, and in Slovakia it was, and it is until the end of the year. So in some other countries as well. So the main logics in all the countries were more or less the same. So the tenants somehow were or are still protected from being evicted, or well, the eviction, it's as far as I understand, is in this case is the consequence of termination of the lease, and there was a ban to terminate the leases. So and a part of that, of course, there were some there were also some obligation of the tenants, of course. In some cases, they had to agree to prolong the lease agreements or something like that. But the general concept and the general logics was that the tenants were protected and not to be evicted.
It's interesting to hear Amanda say that the rent's paid quarterly in England. Our leases are paid monthly by and large. So our tenants who were unable to pay were in default pretty quickly. In April, a lot of them started defaulting. And as I said earlier, while there's no eviction moratorium, we're not seeing a lot of suits for evictions. We're seeing a lot of suits for back rent. But because the courts are so backlogged and the evictions are taking a long time, we're not seeing as many of those as we might expect with all the defaults that we are seeing. To evict a tenant here, you have to go through a legal process of serving a complaint, getting a hearing, and then eventually having law enforcement, if necessary, move someone out if they won't move themselves. But that process is taking a very long time. So what some landlords are doing, maybe a little more than we've seen in the past, are what we call lockouts, which are not evictions. You're not terminating the lease, you're not taking possession, and you're not permanently barring the tenant from the space, and you can't re-let to a new tenant. But you can, if the tenant is in default under most leases in most jurisdictions, lock them out of their space until they pay rent. And that doesn't require a court process. Now, the risk and the reason we've always told our landlord clients not to do that is if you're later found to have done so improperly or wrongfully, for example, to a tenant that has a legitimate force majeure or impossibility defense, you could be liable later for the damages that tenant is suffering as a result of being locked out. Now, early on for sure, and now, if you can't pay your rent, then it's tough to say how much you're really being damaged by not being able to do your business, but that is still a risk. So that's the way things are working out here. Not a lot of eviction suits, some lockouts, but like Amanda said, I think that if people haven't paid their rent in the next few months, and assuming we don't have another wave or depending on what goes on, we could start seeing a lot more of these as the courts open up next year.
Yeah, thanks, David. Let's go to the next slide and discuss the impact liquidation and bankruptcy proceedings might have on the leases and what's the new regulation here. In Russia, there's been a special law adopted which introduced a moratorium to initiate bankruptcy proceedings against debtors in a number of sectors, in a wide number of sectors. Though debtors can still initiate proceedings themselves, but the protection works really well and has been recently extended until the end of the year. That doesn't touch upon the ongoing bankruptcy proceedings. But in addition to bankruptcy, it also suspends the enforcement, and only some restricting orders can be granted, like freezing orders, etc. So this adds a lot of comfort for tenants and for debtors in general. And there's been even a case where within the course of a bankruptcy, the court refused to collect a penalty for delayed rent payment, and despite the tenant was trying to use a force majeure protection, the court ruled out that it's better protected by the moratorium. So the force majeure argument has been dismissed, but the collection process has been stopped, referring to the moratorium protection. That's how it works in Russia, in short. And where I see that Europe has not applicable here, so probably Alexander has nothing to add. Amanda, would you try giving us some glance here?
So in the UK, we have legislation that has banned the service of statutory demands. A statutory demand is the first step in liquidation proceedings. The legislation's also banned the presentation of winding up orders, which again is part of the liquidation process, if the non-payment of the debt is COVID related. And what's interesting is that the legislation places the onus on the creditor, not the debtor, to satisfy the court that non-payment of the debt is COVID related. So in terms of liquidations, there are none that are going on in the UK, but what we are seeing a huge rise of is company voluntary arrangements, and these company voluntary arrangement is a statutory procedure, and it's intended to assist the rescue of a company in financial difficulties. And it allows a company to agree an arrangement with its creditors in satisfaction of some or all of its debts. These company voluntary arrangements are generally used to restructure leases of underperforming properties. So where we've been seeing the huge rise in these is with retailers and restaurant groups who've got large portfolios. And what they tend to do is categorize their leases, those that are very important, those that are very profitable. And so the arrangement would be, or the proposal to the creditors would perhaps be to reduce the rent to 80 or 90% of the contractual rent. And then depending on the profitability of the properties, different arrangements. So in some, it may be that they're handing back the premises to the landlords. For a company voluntary arrangement to be effective, it requires the approval of the requisite majority of creditors. But even if a creditor hasn't approved the arrangement, they're still bound by it. And certainly what we're finding is that landlords of secondary premises are tending to oppose to these company voluntary arrangements on the basis that their properties are going to be handed back to them. But so far, whilst there have been some challenges through the courts as to the legality of the company voluntary arrangements, so far they have all gone through, and I think we're just going to see more and more of this over the next 12 months, maybe longer.
Yeah, most of our bankruptcies in the U.S. are initiated by the debtors themselves, not the creditors, and we've seen already, and there's no moratorium, there's no restrictions on filings, and we've seen a lot of retailer bankruptcies already. It's one of the interesting phenomenons we're seeing are the landlords, the large mall owners that own multiple locations around the country are buying up some of the failed retailers either before or out of bankruptcy to keep their spaces from going dark and bringing down the rest of their centers. And it's a risky venture for developers that are not used to operating retail businesses themselves. They're used to being landlords, but we've seen a series of those transactions lately, and the jury's still out on how that's going to work. But when these, a lot of our bankruptcies are what we call big box or anchor stores, and that does have a big ripple effect on those centers and throughout the industry, because they are often there are co-tenancy provisions where if they're not open, then the other tenants get breaks in their rent and have adjusted rent downward because those anchor stores are now dark. And so the landlords don't want that to happen. The other thing they're doing is they're repurposing those large spaces a lot as bankruptcies happen. And that has a big ripple effect through the industries, not just how the empty spaces affect the other stores, but now how they're changing the use of these spaces. And what had been happening was a lot of those spaces had already been having trouble. A lot of those anchor stores and chains were already going, if not bankrupt, on their way out of business or downsizing or repurposing those spaces. And COVID really accelerated that process. The problem is a lot of those spaces were being converted to what we refer to as experiential retail, where people are doing things as opposed to just buying things. And those places have been really hard hit by COVID because people aren't getting together in large groups to do things anywhere. So right now, that transition has been, I would say, only temporarily halted, but it will accelerate greatly next year because we've accelerated the bankruptcies. So the transition to new uses of these spaces, whether it's for, virtual golf or bowling, or we've got axe throwing places, all sorts of experiential retail that are replacing the old things. I think next year, when things open up, we'll see that trend has been is happening faster than before. But right now, we're at sort of a rough spot in between, where the one set of businesses are going out of business and where it was transitioning to are really not able to come around yet. What we're seeing a lot of is, app-based uses of space where you get deliveries or you pick up things and you're doing it all through your phone. But again, that doesn't allow these spaces to transition to experiential uses, which we can't do that way. So we expect more and more bankruptcies. The bankruptcy department in our firm is gearing up for a big 2021, unfortunately.
Yeah, that's quite expected. Yeah, thanks, David. And I think now we can go to our next poll, which is related to the next topic about insurance. And that's actually a very interesting topic on how insurance coverage can be interpreted in various jurisdictions. So if there is a dispute between a retailer and the insurance company, who shall prevail, one or another? Please use the link below the video player to vote or scan the code while we open up the discussion. I think David was to lead here. Can you put on the next slide? Probably to give David a rest, I'll just say briefly that in Russia there is no solid case law regarding such sort of disputes, real estate, or better say lease insurance. And I doubt that COVID would be recognized as a sort of physical loss or damage coverage, that COVID would fall under this coverage. So please, David, go ahead.
Sure. This is actually the area where we've seen the most litigation and the most decisions, maybe not the most lawsuits, but the one that have generated the most decisions so far has been the fights with insurance companies over business interruption coverage. These policies were not written for these situations, and nobody really doubts that. They were written for hurricanes or things that destroyed a place or business for some limited period of time, usually in some limited geographic area. We just had this week a hurricane come through the Gulf, and in New Orleans and Louisiana and places like that, they're experiencing true business interruption as a result of a natural disaster. The way that the policies are written requires usually the phrase that we're litigating is physical loss or damage. And the question is, does COVID-19 create a physical loss or physical damage to the premises that's the subject of the lease? And while COVID has had an unprecedented effect on the country in many ways, it is a very challenging argument to say that it presents a physical damage to the premises, especially if you can't prove that you've had COVID cases there and that's why you're shutting down. Usually businesses are shutting down as a result of government restrictions or just fear for health and safety, not documented incidents of finding COVID on the premises. So we've had many courts make that distinction and say, this is not a physical loss or damage. There's a quote from one court that said, the virus damages lungs, not your property. And that is a succinct way of saying why most courts have rejected these claims. We had one court so far, and they didn't say that the insured party won, but they did say that the insurance company could not win a motion to dismiss, which in our system is the very first stage of a piece of litigation before there's any evidence. Most insurance companies are winning these cases by saying that the plaintiffs have not even stated a claim under the contract. There's one court that said that a hair salon and a few restaurants that teamed up in one center to sue their insurer, a common insurer, for coverage, that they at least had enough of an argument to take it further through discovery. And they talked about how COVID is emitted through the air, how its particles are left behind. And even as you read that decision, it still seems like a pretty far reach. But one court has said that in the US, there's probably 8 to 10 other decisions in other jurisdictions that have granted motions to dismiss by insurance companies of these claims.
Sounds really scary, David. Amanda, I see that you have a case which sounds like success that you can tell us about.
Partially success. So a test case was brought by the Financial Conduct Authority, which is the regulator of the insurers. And in bringing the case, the FCA were representing the interest of the policyholders. It was the non-damage business interruption cover that was in issue here. The purpose was to determine issues of principle on policy coverage and causation under sample insurance wording. The court found in favour of the Financial Conduct Authority on the majority of the key issues, in particular in respect of coverage triggers under most disease and hybrid clauses, which was obviously welcome news to the policyholders impacted by COVID. However, the court was reluctant to reach any firm decision on whether the social distancing guidance itself and the regulations requiring people not to leave for home without reasonable excuse would be sufficient to amount to hindrance of access or hindrance of use. So it leaves major question open for businesses, primarily in city centres, that weren't actually required by the regulations to close down, but in practice, owing to social distancing rules and the fact that the whole country was discouraged from leaving home, they could not feasibly or commercially continue to operate during lockdown. And furthermore, the judgment didn't address the real obstacle for tenants relying on the rent cessor provisions of the lease, and as David sort of explained, the need for physical damage to the premises. The insurers are appealing the judgment, and due to the importance of the case, the appeal is actually being leapfrogged to the Supreme Court, so missing out the Court of Appeal. So I think that I don't know when the appeal's being heard, but I suspect that it will be this side of Christmas.
So quite soon. Alexander, your turn.
Yeah, well, first of all, I agree with my colleagues that this kind of business interruption insurance, they were designed for different kind of cases. This is I absolutely agree. And the thing is that what we faced during the COVID lockdowns and we're facing now is that many landlords, they're just now requiring the new type of business interruption insurance, and they want this clause to be included in the insurance, and they put some limits like some numbers, what coverage shall we have, and this of course for the business it's quite challenging because I mean we are a big company, a big group, and we have a group insurance which covers like umbrella insurance, let's call it, and which covers all the subsidiaries we have in the world. And of course, to renegotiate something with respect to insurance, well, first of all, business-wise, it's a big cost. And the other thing is that the insurance companies all over the world are still not really ready to modify the insurance policies. And also this will be, as far as I understand, this is a new product for them. They don't know how to deal with this product, how to include this COVID insurance clause into the insurance policy. So for the moment, given that we we're a big company, we can defend ourselves and we just say no to all of the landlords. But the thing is that we never before we faced this kind of requests, and now they're more they're just more persistent, and they are just asking us for this.
Yeah, indeed, the new reality, as you mentioned that on your slide, Alexander. We can now go to the poll results, and it's again the effect of our tenants protective audience that says that 60% think that retailers should be prevailing, while only 40% say that insurance company prevails. So you have good chances in your case, Amanda, and way to go, David, for the US courts. We have 2 topics left, and we're slightly behind the schedule. So I think we would use maybe 15-20 minutes more and get to the end of our discussion. Let's go to the next slide. And Alexander, I think that you were to share your experience in negotiations across various jurisdictions Mango is in.
Yeah, thank you very much, Andrey. That's true that we have quite big experience now negotiating the COVID clauses, and of course it depends a lot upon the legislation of a particular country. And once again, I have to say that we're lucky that we're a very well-known brand. We're an anchor brand for the landlords in mostly all the countries in the world. So shopping centers, they will think twice before cutting negotiations with us. So this is our advantage, which we're using. At the same time, in some of the countries, as I mentioned also in the presentation, in some countries, the landlords, like in Czech Republic and in Slovakia, the landlords are really motivated to agree on rate abatements because the more they give, the more discount they give us, the more they get from the state. This is an interesting system, which they elaborated in each of the countries. And well, there are certain limits, and in case the landlord gives us a discount in Slovakia, for example, for a discounted amount of 50%, this is up to this amount. The same will be paid by the state to the landlord. So it's quite a fair system. It's fair to the landlord. It's fair to the tenant. I just wanted to say also that, for example, now it's a new challenge in both of that countries, particularly Czech Republic and Slovakia, because recently they started they started a new lockdown, let's say, and for example, in Slovakia, the situation is a bit complicated because according to the current law, to a new decree, people are not allowed leaving their homes before they have a negative coronavirus test. At the same time, the shopping centers are not closed, so the decree does not say that the shopping centers have to be closed. And this is also a new big problem for us as a tenant, because business-wise, we're not interested in having any shop open, because there is no benefit. And there will be now a new wave of negotiations, and because we need to somehow negotiate this as well. And what is really and what was achieved and what is really achievable during the negotiations is every type of let's say help. It's the deferrals, abatements. In many countries and with many landlords, we agreed only on the variable rents, on the percentage rent conditions for a long period of time. I don't think I'm disclosing now some commercial secrets, but for example, in some countries, and in Russia in particular as well, we even were able to agree that we don't pay any fixed rent till the end of 2021, and we just pay the percentage rent, which is really a really good achievement, because then we're not depending on the fixed rent we pay. So I think that the most important is is what brand. I mean, if your brand is strong enough to defend your position in negotiations, then you can get quite a lot, and you can get quite good conditions. In case you're a small middle brand and the landlord is not really interested in you, then you might face some problems in negotiations. So this is our experience.
Amanda, what was the situation with renegotiating lease terms in the UK?
So it's very varied, and it's interesting what Alexander's saying about your worth as a tenant. I mean, we're finding that some landlords have sought to engage actively in discussions with our tenant clients, and similarly our landlord clients. Concessions negotiated have been very varied. In the main, they're deferrals of payments rather than abatement of rent. Some landlords have agreed part variable rents based on turnover, because in the UK, it's the norm that rents are a market rent, although in shopping malls it can be both market rent and a turnover on top of that. The government was concerned that there were some landlords who were acting very aggressively towards tenants when we were in full lockdown, and they subsequently published a code of practice for commercial property relationships. It's a voluntary set of principles, and it's to encourage transparency and collaboration between landlords and tenants, so that the parties are acting reasonably and responsibly to identify mutual solutions, i.e. affordable rent solutions, having regard to the impact on COVID. The overarching message of this code is the spirit of we're all in it together. Many take the view that the code makes little or no difference. It has no teeth because it's voluntary. Nevertheless, the code's expected to remain in place until June 2021, and there is some talk of actually making it mandatory, so that there are some, so it does have some teeth. But the reality is that whilst many landlords and tenants have acted responsibly and have tried to negotiate mutually acceptable terms, there are many tenants who don't engage with their landlords and have buried their heads and avoided acknowledging their contractual obligations. Equally, there are landlords who've maintained a very aggressive stance towards the tenants. But where we're heading is that, I mean, our last quarter day was September, and the statistics say that only 22% of rent was collected from shops, offices, warehouses, and leisure premises. So we've got a long way to go.
That's interesting that you say that. In our report for last month in the US was that 83% of rents had been collected from retailers, which is down from an average of about 95% for every month, and certainly, for the year before, but way up from the summer when we were down below 50%. So while you could say what you want about the politics of our reopening, and the COVID numbers in our country certainly speak for themselves, we have reopened, people are making money and paying rent. There's certainly been a health cost to that, but there's still a lot of negotiating going on. And I would say one of the pieces of good news out of all this is that by and large, most of these leases have been negotiated successfully for lease amendments, like you folks have spoken of, whether it's deferrals, which is primarily what we see, and we may have litigation later when those things have to be paid back. We have seen a fair number of abatements, at least short-term abatements early on in the spring of the year. And I know lately for both landlords and tenants, I'm pushing the variable rent, the percentage rent deals, which I think are the most realistic, workable solutions. But I'm getting a lot of resistance from landlords to doing that. But I think it's the most realistic scenario with the uncertainty of how COVID's going to continue to impact businesses. And we are starting to see more head to litigation now. But I've got, just as an example, one client with about 450 locations, and we've got a bucket of, I'd say, 10 or 15 that are still problems where we don't have deals, which some are in litigation, some are, still negotiating, but that's not too bad a percentage of success rate for negotiating lease amendments.
Well, yeah, thanks, David. For Russia, just briefly, Russians are known for their litigious approach, and the access to justice is not expensive, so it's quite easy to compile a claim and file it into court. However, there have been a lot of attempts to negotiate, and depending, as we have already discussed, depending on the leverage of the sides, the results could have been either positive for the landlord or for the tenant. Deferrals have been in use a lot. I've not seen a lot of abatements unless under very, ideal storm situations where both parties understood that it's either this way or no way forward. For instance, for classy Moscow business centers, there was a lot of reluctance to renegotiate anything on office space. But if you speak of shopping malls, of course, there's been a lot more flexibility there, and percentage deals, etc., is something that starts to evolve. And I think it's a good time to get to our last topic and to our last poll. Let's take out our crystal ball and think when will this situation recover, and if it will ever recover and stabilize. So use the QR code and the link to vote while we would act as magicians and try to prognose the situation. Amanda, what's it that you see in the UK?
So in the short term, I think parties are going to continue to look at alternative options. The legislation, while supporting tenants, as I said earlier, is only pushing the problem into the long grass. The landlords are under increasing pressure in terms of servicing their own banking obligations. Just yesterday, we saw a landlord of a major shopping mall being placed into liquidation. I think what we're seeing is that in order to secure the survival of their respective business interests, landlords, shops and restaurants are now joining forces to lobby the government for what they're referring to as a property bounce back grant. The proposal is basically asking the government to fund up to 50% of the rent and service charges owed by the businesses in these sectors, and the grant being conditional then upon the landlords and the tenants agreeing arrangements between themselves for payment of the remaining 50%. I think that lobbying is going to get some traction, and we will be seeing some green shoots coming from that. In the longer term, we're going to see a shift in the dynamics of the landlord and tenant relationship. Up until now, the relationship has always been master-servant. But I think the pressure on both sides is increasing to such an extent that it's going to be, the relationship is going to be that of partners. It's going to be more collaborative. So I think tenants are going to want more flexibility. They're going to want shorter leases and perhaps additional break options. I think typically where rent has been payable by reference to the market, we're going to see more leases with rents based on turnover. I think a turnover lease lends itself to a more collaborative approach where both parties' interests are going to be more aligned. What we're also seeing is repurposing of space, something that David spoke of. We are seeing shops, particularly department stores, seeking planning permission to convert some of their space from retail to offices or residential. And you know, the other longer term is that I think that there is an awakening among businesses that employees are capable of doing work and being productive from home, meaning that current offices are no longer going to meet their needs. So again, whether we see repurposing of office space to residential. So that's how we see things moving in the UK.
David?
There are a lot of similarities, so I won't repeat a lot of what Amanda said, especially due to our time. I think we'll see a lot of those same trends. I think there had been intention maybe before to change, to transition some retail to office because a lot of our, as I said earlier, a lot of our larger anchor retailers were struggling anyway. I think that trend is not going to happen now because office space is in less demand than ever. Many of us have learned we can be very efficient from our homes. I know a lot of office spaces will be probably getting smaller and sharing spaces, something called hoteling, where several people use the same office on different days. Things like that might happen that didn't happen before. I do think the other trends will be accelerated as far as repurposing space, and we spoke a little bit about that. And I agree. I think that there's going to be stronger force majeure clauses. They're going to be negotiated a lot harder on both sides. You're seeing more discussions of variable rent. I think Amanda refers to that as turnover rent. We refer to it sometimes as percentage rent, but a more realistic picture of paying a percentage of what you're bringing in as opposed to a fixed rent payment. And I think the overall change that we'll see everywhere is a permanent rise in app-based and internet-based retail, where that was already a trend, and now because of the necessity, our businesses have learned how to do their business more on the internet, people picking things up at the curbside or having them delivered through an app-based delivery service. I think that was already a trend, but that is accelerated greatly and is here to stay for sure. I do think, though, people will enjoy getting back to restaurants, getting back to movies, and the things that were doing well before will do well again. It's just taking a little longer than we expected.
Yeah, David, absolutely. A lot of good experience behind, and hopefully we'll get back to that. You mentioned the online retail sales, and we might be asking Alexander again to disclose some of his commercial secrets here, but I'm sure that there is, it's obvious that those retailers that were able to arrange that in advance or fast enough during the pandemic, I mean the internet sales and app sales, etc., appear to be really successful.
Yeah, so well, first of all, I just liked a lot the metaphoric expression of Amanda describing the relations between the landlord and the tenant, master and servant, and this is the expression I was looking for many years, thinking of that. And now I do agree that I think that they will become a bit more balanced, and so it will become more and more the market of the tenant, where a tenant can ask for more. And I'm pretty sure that I'm just now, well, my crystal ball tell me that the rental rates for I'm talking now from the retailer perspective. So the rental rates will decrease, I think so. And the other important thing, as you said, Andrey, is that, well, if we're talking about the commercial figures, I can disclose another one. Our company, we have like 1,500 shops all over the world. And during the pandemic, in the worst moments, 95% of them were closed. So you can, of course, understand how much, how huge was the impact on the economy of the company. And at the same time, well, luckily, we developed a lot of our online business during last years, and this helped a lot during the pandemic. And surprisingly, in some of the countries, like big European countries like Germany and, well, for example, Russia as well, there was a huge online interest and huge online sales. So like much more than we could even expect. So, and this, of course, helped a lot. And I think that this is the future where we all, so this is the trend that will be developing.
Yeah, thanks, Alexander. Well, I wouldn't be adding anything that we have here on the slides and what has been said already. I love the experiential real estate term. So I think it seems that we're all very much experiential here, and lawyers become experiential working from their home. It's experiential and experimental. I have the poll results in front of me, and it's a bit like a touch of pessimism on on our audience. Over 80% of them think that it's either January 22nd or later that things will stabilize. Well, frankly, if stabilize meaning return back to what we used to, I think the response is never. The changes are indeed drastic, and that's not only in regulations and the economy, it's the mindset. So with this, I think we can check again if there's been any new questions in the chat. I don't see anything like that. So maybe with this we can switch on the slides with contacts, so that any follow-up questions, emails, etc., can be sent to the speakers directly. Thanks a lot to the panel, a lot of insightful information. Thanks a lot to the organizers and to LF Talks and the particular people behind the screen that helped us to arrange this. Thanks a lot to the audience and for your questions. Keep safe and look forward to our next event.
Thanks, Andrey. It's been a pleasure.
Pleasure. My pleasure. Thank you.